Look, I've been telling this story to my old crew at the Elks Lodge for months now, and every single time somebody just shakes their head and says they can't believe how it played out. But I'm going to tell you exactly what happened, start to finish. My name is Jack Mercer. I'm 56 years old, and for the better part of 18 years, I was the Senior Hazardous Materials Compliance Director at Calloway Chemical Solutions, one of the largest specialty chemical suppliers to the American defense and aerospace industries, until a Tuesday afternoon in March when my daughter-in-law's college roommate walked into my office with an HR folder and a practiced, sympathetic expression. "Jack," she said, "the company is moving in a new direction. Your role is being absorbed into our new centralized logistics platform. We really appreciate everything you've contributed." I was sitting there with my special permit binder open on my desk, the one I'd spent 3 years negotiating with the federal government, and all I could think was that this woman had absolutely no idea what she was holding in that HR folder. Let me back up. Calloway Chemical Solutions dealt in a compound called Thermoplex 9. If you've never heard of it, that's fine. Most people haven't. It's a proprietary thermal stabilizer used in missile guidance systems and certain classified aerospace applications. The stuff is extraordinarily effective at what it does and extraordinarily regulated because of how it has to be transported. One wrong temperature fluctuation, one incorrect container seal, one driver who doesn't understand a specific emergency response protocol, and you've got a federal incident on your hands. Years ago, when our previous compliance director retired, I spent 31 months working directly with the Pipeline and Hazardous Materials Safety Administration, PHMSA, to obtain what's called a Special Permit Authorization. It's essentially a federal document that says our company is approved to transport Thermoplex 9 under a specific set of conditions that we designed, that we tested, and that we proved to regulators. The permit is tied to a designated compliance officer. Me. My name, my federal identification number, my professional certifications. The permit is non-transferable. If I leave, the permit enters a mandatory reapplication process that takes, at minimum, 14 months. The company didn't fully understand what that meant. My new boss certainly didn't. Her name was Kayla Brennan. 32 years old, Wharton MBA, sharp as a tack in a boardroom and completely without a clue about what it actually takes to move restricted chemical compounds across state lines to a Department of Defense facility. She'd arrived at Calloway about 14 months before all this happened, brought in by her father-in-law, our CEO Donald Calloway, to lead a massive operational restructuring, modernize the supply chain, eliminate redundancies, reduce headcount, migrate everything to an integrated digital platform. Classic MBA playbook. I want to be fair to her. She was genuinely intelligent and genuinely ambitious, but intelligence and ambition, when applied to an industry you don't understand, are more dangerous than plain incompetence. Incompetent people tend to ask questions. Kayla never asked questions. She made decisions. Our first real collision happened about 4 months into her tenure. She drafted a proposal to outsource our hazmat transport to a third-party logistics company out of Memphis, a firm called Streamline Pro that handled automotive parts and medical devices. Good outfit for what they did, completely unequipped for what we needed. They had no PHMSA hazmat training infrastructure, no experience with restricted chemical protocols, and no pathway to get our Thermoplex 9 shipments federally cleared. I wrote her a detailed memo explaining exactly why this wouldn't work. She wrote back a 3-line response thanking me for my perspective and noting that the logistics committee would take it under advisement. 2 weeks later, I got a CC on an email showing the Streamline Pro contract had been signed. I escalated to Donald, our CEO. He listened politely, made some notes, and then said, and I remember this very clearly, "Jack, give Kayla a chance. She's smart, she'll figure out the details." The details. Like federal law was a detail. What saved us that time was that our primary defense client, Meridian Aerospace Systems, a Tier 1 contractor supplying guidance components to the Air Force, happened to have a compliance review coming up. Their own inspectors flagged that our proposed transport provider wasn't cleared for Thermoplex 9. The contract got put on hold pending resolution. I quietly stepped in, worked with Meridian's compliance team to revalidate our internal transport protocols, and got everything back on track through our existing licensed approach. The Streamline Pro arrangement died without fanfare. Kayla never fully understood what had happened. She assumed the logistics transition just needed more time to implement. I started keeping very detailed records after that. For the next 8 months, it was a steady rhythm of Kayla pushing towards speed and simplicity, and me maintaining the regulatory infrastructure that actually kept us operational. She replaced our quarterly PHMSA compliance reviews with an automated dashboard that flagged deviations in transit data. I kept doing the quarterly reviews anyway, on my own time, because I understood that an automated dashboard cannot anticipate a federal inspector's specific line of questioning. She consolidated our chemical documentation into a cloud platform that wasn't properly configured for controlled document access under ITAR requirements. I flagged it, it got fixed. Eventually, but only after I escalated 3 times in writing. I heard what she said about me in meetings the same way you always eventually hear what people say about you. Too process heavy, too slow, has to sign off on everything personally. Jack's a good guy, but he's built walls around himself to make himself feel indispensable. Indispensable. She used that word like it was an insult. I thought about walking into her office and explaining exactly how indispensable I actually was, but I'd spent enough years in compliance work to understand that the people who announce their own value are usually the first ones escorted out. You don't protect yourself by making noise. You protect yourself by doing your job so completely, so thoroughly, that the consequences of removing you are written into the foundation of the operation itself, which they were. My name was literally on the federal permit. The contract that brought everything to a head was the Calloway project. Meridian Aerospace had won a major production contract for a next-generation targeting system. Classified tier, substantial volume, tight timeline. To supply the Thermoplex 9 required for that program, we were looking at a 22-month commitment worth $340 million. Our biggest single contract in company history. Kayla led the pitch. It was a good pitch. She was a skilled presenter and the numbers were solid. I handled the compliance section, walked Meridian's procurement team through our transport certifications, our federal special permit, our emergency response protocols. Their compliance director, a retired Army colonel named Frank DeMatteo, asked me 3 very specific questions about our PHMSA authorization chain. I answered all 3 cold, no notes. He looked at me with that flat military expression and said, "Good, we need to know this when we call you at 2 in the morning." Frank and I had worked together on 2 previous Calloway Meridian contracts. We understood each other. We got the Calloway contract. It was announced internally on a Wednesday. By Friday, Kayla was in Donald's office presenting a new organizational chart. I know because Sarah from finance told me about it over coffee Monday morning. She'd seen it on his desk when she dropped off the quarterly report. My box was gone. I called in a favor with an old colleague that week, a man named Gary Pollard who'd spent 20 years as a federal hazmat inspector before moving to the private sector. I asked him a hypothetical. If a company holding a PHMSA special permit for a restricted compound changed their designated compliance officer without filing a permit continuity application, what happens? Gary didn't hesitate. Automatic 72-hour operational hold on all shipments of that compound. Then a full permit review that runs a minimum of 14 months, sometimes longer if the new designee has to build their certification file from scratch. And any existing federal contracts that depend on active permit status get flagged for compliance review. Every single one of them. I thanked him and told him I was just brushing up on the regulations. That was a Thursday. On the following Tuesday, I got the visit from Kayla's assistant with the HR folder. I want to tell you exactly how that conversation went, because the details matter. Kayla came in herself, which I'll give her credit for. She didn't send someone to do it for her. She sat down across from my desk, put the folder between us, and explained the new structure. My compliance function was being integrated into the operations platform. They'd identified a candidate, a 30-year-old named Tyler Marsh, who currently managed compliance documentation for a food and beverage distributor in Cincinnati, who would take over my responsibilities under the new framework. I asked her very calmly whether Tyler had his PHMSA restricted chemical special permit designation. She blinked. The what? I explained it to her. Slowly, in plain language, the same way I would explain it to a new hire on their first day. She wrote something down on her notepad and said they'd handle the transition details. Effective date was 2 weeks out. I cleaned out my office over those 2 weeks without saying a word to anyone about the permit. I answered every question that came to me professionally and completely. I documented everything I handed off. I processed every pending item. I wrote a thorough transition document, technically accurate, complete in every way except for one thing I did not volunteer. I did not explain that my departure would automatically trigger the permit hold, not because I wanted the contract to fail. I want to be clear about that. I didn't want Meridian to miss a production deadline. I didn't want our shipping team to get caught in a federal hold, but I had spent 14 months watching Kayla make consequential decisions without consulting the people who understood the consequences. She had been told directly that the compliance infrastructure was mine to manage, and she had spent a year systematically deciding she knew better. I was not going to walk out the door delivering one final rescue. Some people have to learn on their own terms. My last day was a Friday. I shook hands with the people I respected, said professional goodbyes to the rest, and drove home. Made myself a drink, and sat on the back porch watching the yard go dark. I didn't call anyone, didn't post anything online, didn't send a warning. When you understand how a system works, you don't need to do anything dramatic. The system does the work for you. Monday morning, I was making eggs when my phone lit up. Gary Pollard. I let it ring. 40 minutes later, another call from Frank DiMatteo at Meridian. I let that one ring too. I knew what was happening. I just didn't need to narrate it. What I learned afterward, in pieces over the following 2 weeks, painted a very clear picture. When my access was terminated Friday afternoon, the PHMSA federal database automatically registered a change in the designated compliance officer for our special permit. That change, without an accompanying permit continuity application, which takes 30 days to prepare under normal circumstances, triggered the 72-hour operational hold on all Thermoplex 9 shipments from Calloway Chemical Solutions. Monday morning, 3 transport trucks heading to Meridian's facility in Virginia got flagged at a weigh station by a federal inspector running routine document checks. The drivers had no idea anything was wrong. The inspector pulled the permit records, saw the hold, and placed all 3 shipments under federal quarantine pending compliance review. Frank DiMatteo had been in the industry long enough to know exactly what he was looking at when his receiving dock called him. He went straight to his legal team. By noon, Meridian had issued a formal compliance suspension notice to Calloway, freezing all activity on the Holloway contract pending restoration of valid federal permit status. Calloway's stock dropped 11% before the close of trading. Tyler Marsh, meanwhile, had spent his first week reviewing the documentation system and attending onboarding meetings. He was a perfectly competent person who had absolutely no idea that the job he'd been hired to do required a federal credential that took years to obtain. When someone finally explained the situation to him, he reportedly asked whether they could just list someone else's name on the permit until he got his certification. That's not how federal permits work. Kayla called an emergency meeting Monday afternoon. From what I heard through mutual contacts, it did not go well. She presented the hold to the executive team as a temporary administrative issue that could be resolved quickly. Donald asked her how quickly. She said she'd have an answer by end of week. He asked Frank DiMatteo's name from the Meridian notice and went very quiet for a moment, because Donald had been the one who'd originally met with Frank and personally guaranteed the compliance infrastructure. By Wednesday morning, the story had made its way into an industry newsletter, one of those insider defense contractor publications that maybe 3,000 people read. But those 3,000 people are exactly the people you don't want reading about your federal compliance violations. The headline wasn't dramatic, just factual. Calloway Chemical and PHMSA hold. Meridian Aerospace contract status uncertain. In the chemical supply industry, that kind of headline lands like a bomb. I got a call on Wednesday afternoon from my old mentor, a man named Douglas Webb, who'd been in specialty chemical compliance for 35 years before retiring to Arizona. He'd seen the newsletter item. "Son, what happened over there?" I told him. A pause. Then he said, "Well, that's what happens when you let somebody who's never read a federal register make decisions about federal permits." Douglas was never one for elaborate commentary. The board meeting happened Thursday. I wasn't there, obviously, but one of the outside directors, a woman named Patricia Chen, who had her own background in regulated industries, had apparently asked questions that Kayla struggled to answer. How long had the company been aware of the permit structure? Had legal ever reviewed the dependency on a single designated officer? Who had approved the transition timeline? The answer to all 3 questions in different ways was Kayla. Donald, to his credit, didn't try to shield her from those questions. He had 3 other major defense clients calling his personal line asking about their own supply agreements, and he was a businessman who understood which direction the wind was blowing. Kayla's statement to the board about how the disruption could be resolved quickly did not survive contact with reality. 14-month minimum permit review timelines are not things you can charm or optimize or platform migrate your way through. You file the paperwork, you wait for the federal process, and you hope you haven't already lost your major contracts in the meantime. Meridian didn't wait. Frank DiMatteo notified Calloway by Friday that the Holloway contract was being formally suspended pending a 30-day compliance review window, after which they would evaluate alternative suppliers if the hold wasn't resolved. At $340 million over 22 months, that was not a line item on a spreadsheet. That was the majority of Calloway's projected revenue for the year. I heard all of this in pieces, the way you do when you spent 18 years building relationships with people throughout an industry. Phone calls, texts, emails from former colleagues checking in. I didn't chase the story. It came to me. What I will tell you is that I didn't feel the satisfaction some people might expect. There was no moment of vindication where I punched the air or poured a celebratory drink. The whole thing felt more like watching a building settle after the foundation gets removed. Exactly the result physics predicted, exactly the consequence that was always going to happen, playing out on its own timeline. The call I'd been waiting for came 11 days after my termination on a Tuesday afternoon. It was from Donald Calloway himself. I'd known Donald for almost 20 years. He was a hard man, often right, occasionally stubborn in ways that cost him, but fundamentally decent in the way that some business people manage to remain after long careers in competitive industries. He didn't open with small talk. "Jack, I need to understand what we're looking at here with the permit," I told him. All of it, the same way I would have told him any time over the past 14 months if he'd asked. The permit structure, my designation, the reapplication timeline, what Tyler Marsh would need to obtain his own designation, and roughly what the realistic window looked like before Calloway could resume compliant Thermoplex 9 shipments under a new authorization. He was quiet for a long moment. "Then why didn't you say something before you left?" "That's a fair question," I told him. "But I said something about this for 14 months, Donald. Every time I raised a compliance concern, I was told to work within the new framework. The last 3 memos I sent about permit dependencies got no response at all." Another pause. Longer this time. "Is there a path back for us on the Meridian contract?" "Possibly," I said, "but it depends on what Frank DiMatteo is willing to do, and Frank is not someone who responds well to pressure. He responds to relationships and demonstrated competence. You'd need someone you trust to have that conversation." "I know you know Frank." "I do." "What would it take?" I told him. Not to be difficult, not to extract maximum leverage from a bad situation. Just honestly and directly the way I would have approached any compliance problem in 18 years at that company. The permit reapplication needed to start immediately with a properly credentialed compliance director overseeing it. Frank would need a direct call acknowledging the specific failure, not the general business language of operational disruption, but the specific failure. And any arrangement going forward needed to have compliance authority reporting independently, not filtered through an operations platform managed by someone without regulatory background. Donald said he understood. There was a pause, and then he asked whether I would consider coming back as an independent consultant to manage the reapplication process. I thought about it for a moment. Not about the money, though the number he mentioned was reasonable. About whether the thing that had made the situation unsustainable had actually changed, or whether I'd be walking back into the same structure and fighting the same battles. I told him I'd need a week to think about it and that any arrangement would need to be structured in a specific way. I didn't spend that week thinking about Calloway, though. I spent it on a series of phone calls I'd already been planning. Here's something I hadn't mentioned yet. About 6 months before all of this happened, I'd been approached by a firm called Meridian Compliance Partners. No relation to Meridian Aerospace, just a coincidence of name. They were a regulatory consulting firm that worked with chemical and materials companies navigating federal compliance requirements, and they'd been trying to recruit me for 2 years. I'd stayed at Calloway out of loyalty and because the work felt meaningful. After the 3rd ignored compliance memo, I'd started returning their calls. By the time Kayla handed me that HR folder, I'd already had 4 conversations with their managing director. His name was Robert Ashby. Former PHMSA Regional Director, 21 years government service, now building out the most specialized hazmat compliance practice on the East Coast. When I called Robert the week after my termination, he didn't sound surprised to hear from me. "I'd been watching the Calloway situation," he said. "Of course you had. We had a contract signed within 10 days, not a consulting arrangement, a senior partnership. I'd be bringing my federal relationships, my permit expertise, and my PHMSA designation history to a firm that already had 12 clients who needed exactly that. The base compensation was 60% higher than what Calloway had been paying me. The upside, if we grew the practice the way Robert and I both believed we could, was considerably more. I did call Frank D'Amadio before I finalized anything, not to broker my own return to Calloway. That conversation was Donald's to have. I called because Frank deserved a direct explanation from someone he trusted, and because 18 years in this industry had taught me that you protect relationships even when you don't immediately benefit from doing so. Frank, I told him, here's exactly what happened at Calloway, and here's what their realistic timeline looks like. I'm not asking you to hold the contract. I'm just making sure you have accurate information to make your decision. He was quiet for a moment. Then he said, Jack, I put your name on that initial RFP specification because I trusted you personally, not the company. You. I know. Where are you landing? I told him about Meridian Compliance Partners. Another pause. Then he said, when you're settled in, give me a call. We've got 3 other chemical supplier relationships that need a compliance review, and I'd rather have someone I know doing it. I wrote down his number even though I already had it memorized. I did not go back to Calloway in the end. Donald found a path forward, hired a qualified compliance director from a competitor, started the reapplication process, worked with Frank on a modified timeline that got the Holloway contract reinstated in a limited form about 4 months later. They lost approximately $180 million in projected revenue during the disruption window and took a significant reputational hit in the defense supply community. The stock recovered partially but never fully got back to where it had been. Kayla was moved to a domestic retail distribution role about 6 weeks after the board meeting. Corporate speak for as far from federal regulatory exposure as we can possibly put you. Her modernization platform, the digital compliance solution that was going to replace what I did, was quietly shelved. Donald brought in an outside firm to assess what additional regulatory dependencies existed in the business. That review apparently took 4 months and produced a report that was, by all accounts, uncomfortable reading. Donald retired about a year later. The press release mentioned a planned transition. People who knew him said he'd aged noticeably in those last 12 months. I don't keep close track of any of it anymore. Not out of bitterness, genuinely I don't carry that. It's more that the chapter closed, and what came after it is so much more interesting that looking backward just doesn't have much appeal. I'm a senior partner at Meridian Compliance Partners now. We've grown from 12 clients to 37 in under 2 years. I'm working with companies across the chemical, materials, and defense supply industries who actually want someone in the room when they're making decisions about regulatory structure. My phone rings at 2 in the morning sometimes, not because something has gone wrong, but because a client has a question they want answered before a 6 a.m. filing deadline, and they know I'll pick up. Frank D'Amadio is one of our clients now. He moved to a new role as Chief Compliance Officer at a larger aerospace firm last year, and one of his first decisions was to bring us in for a full regulatory audit. We had lunch in Washington when the engagement started. He ordered the same thing he always orders, complained about the same things he always complains about, and at one point looked at me across the table and said, "You know, I knew something was off that day when you walked out of that Calloway meeting room. You were too calm." I told him I'd known how it was going to end. He nodded. "Yeah, that's what I figured." Robert Ashby and I are expanding the practice next year. 2 new partners, both with federal agency backgrounds, both with specific expertise that their clients genuinely cannot replace with a software platform or a recent graduate. We're building something that's worth building because we understand the thing Kayla never quite grasped, that in regulated industries, the relationship between expertise and compliance isn't a legacy structure waiting to be disrupted. It's the foundation. You can build a lot of impressive things on top of it. You just can't remove it and expect the building to stand. A few months ago, a new client of ours sent their VP of operations to our first onboarding meeting. Young woman, late 20s, Columbia MBA, clearly very sharp and clearly under the impression that her primary job was to find efficiencies in our engagement structure. About 20 minutes into the meeting, she started asking whether our compliance review process could be partially automated. I looked at her for a moment, not unkindly, just steadily. Then I said, "Let me tell you about a company that decided their federal special permit was an administrative formality." She put her pen down. She listened to the whole story. asked 3 genuinely good questions when I finished. At the end, she said, "So the lesson is that compliance infrastructure isn't overhead, it's load-bearing." I told her that was exactly the lesson. She took notes, which I appreciated. Some people learn from other people's mistakes. Those are the ones I like working with. They're the ones who call before the problem happens, before the federal hold, before the board meeting, before the stock price tells the story in numbers that can't be explained away. As for Calloway Chemical Solutions, last I heard they'd stabilized but remained a considerably smaller operation than they'd been during the Holloway peak. Tyler Marsh moved on to another company after about 8 months. No hard feelings. He was in an impossible position from the day he was hired. And me? I'm sitting in an office with a window that looks out over the Potomac, working with people who understand that in this business, the most expensive thing you can do is underestimate what you don't know. The second most expensive thing is letting someone who doesn't know tell you that the person who does know is just slowing you down. I built 18 years of relationships, certifications, and federal trust so carefully that removing me from the picture automatically froze a $340 million contract. That's not indispensability as a personality trait. That's just what doing the work correctly looks like, over time, in an industry that demands it. Sometimes living well after someone told you you're obsolete is the only statement that needs to be made. And that's enough for me.